OPD
Okay.
in Multnomah County Department.
Yeah. I did a site review for OPDS a number of years ago of Multnomah County juvenile practitioners. So I was on a team, I think Tara might have been on it, but Professor Harris from U of O was our leader, and Ingrid Swinson was on the team with us.
Okay, I might not have been practicing then, depending on when it was.
Yeah, it was a long time ago now, like probably, I don't know, like 15 years ago or more. Yeah.
I did a short stint in juveniles for maybe 4.5 years, 5 years, and then God, almost 20 years ago. Yeah.
This is what happens when we practice for so long. Like, right?
Well, just got to bounce around. It's like what keeps you interested, right? Like do a little of this and then learn that. And I don't know if people had a chance to see it, but I just like did a brain dumpy document and sent it to everyone.
Yeah, I saw it.
It was just like me trying to,
Dawn, but I didn't look. I didn't read it. I'm sorry. I didn't get a chance to read it. I've been in court until just 2 minutes ago. So,
well, some people might think you didn't miss much. Yeah, it was just my way of like taking everything I've been seeing and hearing and like, okay, this is what I need to think about in a textual way. Next comes the flow chart. What are those things they call them with the circles and the arrows going? Mine. What are those called? You know what I'm talking about? They'll
flow
be
charts.
Yeah. Like, yeah, maybe some other words gonna
Venn diagram. Venn.
Yeah.
Venn. Is it a Venn diagram? There you go.
Overlap circles. Gotcha.
Venn. Yeah, I don't know. Is it Venn? If then go there. If this go there. If not go there. I don't think I'll ever get that fancy, but maybe.
Okay. I think, well, we've got five plus me, so I think we can get started. Dawn, thank you. This is actually very helpful. So I also sent something out as well. If folk had an opportunity to look at that. If not, I can go ahead and throw it up on screen too.
Are you talking about like it says draft and then it's yeah.
Yeah.
Okay.
That's my initial thought based off of what we put together, what we talked about last week. Oh, full screen. I don't want to share the whole screen, just the one. That was my thought for, it's weird. There we go. Okay. That was my thought based off of what we talked about. There's stuff missing from this. And I think some of it is just stuff we haven't talked about yet. There's a whole categorization. Dawn, it looked to me from what you sent in earlier today as well that you're kind of in favor of some kind of a hierarchy, at least with TPR, ICWA, and possibly extreme conduct. You brought up something that I completely forgot to mention last week, which is we also have possibly the choice of splitting parent and child representation into separate qualifications. There are states that do that. I don't know that that's a direction that we want to go, but I'd love to hear feedback about those as well. I mentioned in the email last week after as the wrap up, my hope is to maybe take a stab at fleshing out some of the bare bones qualifications for adoption, and I'm not sure about voluntary placement agreements and whether they need something different. But okay, I see you shaking your head too. I'm gonna open back up the floor and let's talk some more about this. We've got a little bit more defined, and we've also got some open areas. Holly, go ahead.
So I don't know how many people were able to go through and read all of the materials in the Dropbox, like from the other states, but in going through all of those, I was really struck by the fact that whether they were relatively newer standards, like within the past couple of years, or were like even more outdated than that, I felt like a lot of what we are focusing on was way above anything I read. I mean, like way above. So one thing that I really liked, and I wrote down from two different states. So one was Washington State did have a distinction between regular dependency work and TPR, but it was only requiring 6 months. They only require 6 months of dependency experience or significant experience in handling complex litigation.
Yeah.
So, but at least it's something, right? Like, it's like you cannot just pass the bar and start and represent people on TPRs. So
Right.
I did like that. The other thing out of the Washington State standards that I really liked, which I feel like a lot of what, like even in Dawn's notes, in the notes that Kevin, you wrote from our last discussion, was the just some basics that every lawyer, no matter what they're doing in dependency, need to have. So knowledge and training and experience, ability in communicating effectively with children. So a distinction there about and participating, like this was Washington State, in at least one consultation with an experienced attorney who already would have been certified. And then the idea of familiarity with services and treatment resources for substance abuse. That was the Washington standards that I pulled out. Arizona, also, I liked some of what they had in regards to, and it's again kind of off of the discussion we had previously, but a minimum amount of some kind of training hours. So they have introductory that before you can start, you must have 6 hours of court approved, which in this case, I think would be more like OPDC approved training prior to getting your first appointment of any kind. Then you have to have 2 additional hours in the first year of practice. And then every year you must have 8 hours of continuing education. And they have a laundry list around like mental illness, dependency law, how to read a psychological evaluation, domestic violence, trauma, cultural awareness, motivational interviewing, child and adolescent development, ICWA, immigration, et cetera, et cetera. So I think that goes along with something that I took away from last time, which was that I really do feel like we should have some amount of required training up front before you start, and then some kind of ongoing. But I did not find anywhere, even in New York standards, which were exhausting to read, that there was something, the bar set so high that you couldn't take a case until you had all this experience. Like we basically already kind of have. You have to have already been misdemeanor qualified, or you have to have some kind of equivalent. So I didn't see that anywhere else. So I just wanted to throw that out there for those that may not have gone through that.
And so here's a few other, Dawn, I see, but let me go ahead and tag on to this real quick. Here's a few other samples from those documents. Arkansas requires 10 hours of specific CLA work within the last 2 years prior to certification, and it has to be done by the agency or certified by the agency that oversees the program, and then every year an additional 4 hours of CLE with an explicit, if you fail to do this, you're out. There's some parameters in there to help people catch up, but DC has a 16-hour training on the law, the standards, permanency options, ethics, trial skills, and observation, and assigns you to a mentor as part of the first year, and asks for experienced attorneys to get CLE time for mentoring. Rebecca, I'm going to chime in here that yes, it was very heard that we don't necessarily want people to be doing the mentorship for free. because that's a lot to ask. And then an additional 12 hours every year of CLE, one of which must be on trial evidence or ethics, and another must be on multidisciplinary practice, and a lot of other options as well. Ohio requires 1 year of practice as an attorney or 6 hours of a juvenile law CLE and a special certification to be a GAL, which we don't have here. That's different, and I don't think we want to worry about GALs. It's not a GAL for a parent, it's a GAL for child, which is just a dramatically different thing. North Carolina requires you to have read the juvenile code and performance standards, observe 8 dispositional hearings, review hearings, or permanency hearings. There is no requirement that any of those be contested, and observe 1 contested adjudication, and then 1 hour of CLE every 2 years. Yeah, I think we could probably do better than that. And then to be certified for TPR, they also break it out. You must have a year of dependency experience and have observed 1 contested TPR. Florida's, they have this whole board certification thing that they do in a whole bunch of practice areas. And so there are high requirements to become board certified. I'm not sure that really is applicable here. And then Montana requires you to be knowledgeable in a whole bunch of different things, but doesn't really specify what that means. To synthesize some of this, I agree that I like the long list of CLE topics, but I'm not sure how much I like it for the initial, we think you can do this on your own. I think we may be wanting something a little bit more structured for the initial, and then CLEs, yeah, you're good. There's a wide variety of stuff you can do, but I think we can talk more about that too. Dawn, go ahead.
So I was just putting down some responses or ideas or ways of thinking about it. If we you'll see that at the very top, I kept trying to remind myself of what the goal or purpose of this was by saying the focus on sole practitioners and or just starting out. Okay. I mean, we want to be cognizant of not creating a system that no one can get into and learn how to be a good lawyer. But let's be clear, we have to meet our constitutional and statutory standard of providing a real lawyer that knows what is going on when they're in the courtroom, right? So, and I think to figure out what our qualifications are to just be able to start doing this work, we probably do need to make the decision early. Are we going to set up a bifurcated qualification system where we have qualifications for attorneys that are going to take child cases only, parent cases only, and then a dual qualification? I can tell you right now, I vote against having just lawyers that do kid cases and just lawyers that do parent cases, because I think you are a better lawyer for each one if you understand the whole dynamic and you've worked on both sides of the fence.
Do we want to take a
Bravo, bravo, bravo.
I don't know that anybody
Dawn,
disagrees with you. Okay.
Well, then we don't even need. We can say that we've decided we don't want a bifurcated system. That we believe that since the legislators decided that families benefit from highly qualified lawyers, and the lawyers are better qualified if they can do both. We've decided that question. And my next thing was like training provided as we set up these qualifications. Kevin, my question is Office of Public Defense Services going to create a training that, say I move here from South Carolina where the law is really different, and I've been a lawyer, and I'm thinking I know how to lawyer. You don't. I can quickly get you information and prove to you that I know how to cross-examine, that I know where to find the rules of evidence and how to utilize the rules of evidence in a courtroom. And I can investigate. I understand the basics of investigation and stuff. But would you have a training that I could go to? Because I've been practicing long enough. Hypothetically, the bar is going to let me in without having to do too much, right?
Sure.
That I'm thinking, oh, I'd like to be a contract lawyer. I'd like to provide indigent defense work. Are we also, as we update the qualifications, going to create a training that the Office of the Public Defense Commission is going to agree meets the standards, or some kind of a test I could take for knowledge? Because you'll see that my vision included like kind of a bifurcated way to get there. I demonstrate some skills, maybe lawyers write letters, or I can get a transcript because maybe I've been doing some adult work or something. And then I need to just show, hey, I can either find the law and understand how to read it and interpret it, or I've got it memorized with an open book test. So if we're going to have that training, then we should put in we should clearly say in the qualifications, you need to attend this training before you start, even if it's an online training.
So the short answer is I don't know. The longer answer is all of the Resource Council attended the NEPD Train the Trainer course last year. No, it was this year. Good Lord. That was this year. Guys, it's been a long year. So and I think ideally, yes, that is the goal, is that we will create and possibly also find trainings that are made by other organizations that fit what we are looking for and certify them. So the way that we're kind of approaching this is that the training doesn't have to be ours. Like OPDC doesn't necessarily have to be the ones who created it. OCDLA might have put together a training. I think like for trial skills and trial practice, the Trial Skills College, it's got some overlap. It's more oriented towards criminal practice. I mean, we don't need voir dire, but you know, whatever. So it might fit some of the stuff that already exists that we know about, might fit some of those niches, and we can use those to satisfy components of the certification. I think some things probably can't be trained effectively. Client communication is the big one. That's way more of an experience thing to me. Mentorship would probably fill that gap from my viewpoint, but I'm certainly willing to hear other opinions on that. So yes, training. I think we're all anticipating this is going to be the training is going to be a part of this. It is part of the plan for. I don't know if it will be this work group, but we will. Like this work group is handling the qualification standards and then the performance standards. What I'm unsure of is we are tackling training standards as well, meaning what does OPDC think needs to be in a training to meet what we would certify? I don't know whether that is the realm, whether that's included in this work group's longer term piece at the moment, but that is the goal, is to fold training into this as well. And so I think we would just use the phrase completes an OPDC certified training program for kind of the catch-all. We don't know what it's going to look like yet, but once we do, we have a way to incorporate it.
And then I think my last, before I cede the floor, is you mentioned that the Florida does this board certified, but really I disagree with you, Kevin, that OPDS is certifying us, but you're calling it qualifying us. So we can come up with a system that it's the same thing, really. Before you do this work as a public defender, you're going to be deemed qualified through it because you're going to meet certain qualifications. And some of their qualifications, I think I incorporated a few of the ideas because one of them is they did have a written test
Yep.
and providing some information. So I think you just take out the word certified, put qualified, and take out board and put OPDSC. It's the same concept. I mean, I don't know what Florida does, maybe even to stand in a courtroom doing that kind of work in Florida, the bar expects you to know how to do that. I don't know, but
and I'll see my when I was reading through it, it read more like a marketing thing. Like you can advertise yourself as board certified if you, but you're not, you're also not wrong. Like it's got a lot of similar stuff. The big factor being it requires 5 years of experience before you can
that's too
apply.
long.
Yeah, that's where I was like, okay, now I may need to take a step back from this. There's some good stuff here, but 5 years is 5 years is a lot. I mean, I would barely meet that. So okay.
Yeah, but I think given the fact that we're tasked to come up with something for someone that's a sole practitioner or just starting out, we can't really say 5 years. Like that's
Right.
kind of like,
Yeah.
So
Yep.
I cede the floor. I did my little checklist.
All right. Holly, I think you're up next.
So just a couple of things to go off of what Dawn has listed and what she's mentioned and this discussion. I wanted to, at my age, I got to say it or I'll forget it. So no, is one, I took a class at U of O Law School on interviewing techniques. I found it incredibly helpful. It was, I want to say it was like an adjunct professor. She was an attorney working in Eugene, but and then also, I want to say one of the regular professors at U of O full-time also assisted with that. But for a brand new lawyer, like before when I graduated from law school, I already felt like I had some skills from taking that class. And then I was in a law firm. Of course, I sat in with some of the partners on interviews, but our group, JCDL, our consortium, we've always had it instituted as part of our requirements for our attorneys that they need to partner up with one of the experienced attorneys, that they need to try a case. Like even when OPDC didn't require, like certain things, we required it, and then got feedback from the court, got feedback from the court staff, got feedback from the attorney. So I think incorporating those things, the mentorship of some level, I think for a new lawyer starting out would be appropriate. The last thing on the training issue, like when Dawn was talking about, like if I came here, I'm an experienced attorney from another state, or even if I'm just a brand new attorney, is I think the training could be really easy to do video training. I mean, you have CASA, our CASA office down here does this. They have every single person they can think of. I mean, parents, lawyers, AAG, DHS, and they record them doing the training. And then year after year, the CASAs can watch that and then they get updated. But along with that, I was thinking that I had to do traffic school one time. And as part of traffic school, which was online, you watched a series of videos and then you had to be taking a test during, like at the end of each section, and you had to pass the class to then not have to pay for your ticket and pass traffic school. So it could be the same kind of concept. It'd be really simple, and that way, it goes to that open book test issue of knowing that the attorney has reviewed the materials, has answered enough questions to pass that initial, whatever it might be in that training. And then it would be easily updated from year to year, and
So that was part of the training that we all attended, was how to build a course using an online system. The one that I had envisioned is a mix of online and in person, but that whatever in-person components would be necessary. Ideally, we would have like going around the state and doing local, like quarterly sessions of whatever in-person stuff. So yes, like I want to be sure that we don't focus too much on the training portion right now because we've got to get the rest of this
No, but I just
put
want to make
together.
sure,
But
I think
yeah.
that should be part of our, obviously our standards. And then, like you said, how you build that out. But
Yep.
for those of us down here and in the rural parts of the state, we definitely need something that doesn't require all of us to go somewhere, Bend
Yeah.
or Salem or wherever, to do the training. So that's the only thing I wanted to mention.
Yeah, wholeheartedly agree. It doesn't work if, 3/4 of the like state can't access it on a regular basis. Yeah, totally agree. Melissa.
I'm not going to repeat all the comments everyone else has already made, but I think that we just need to remember this is like the base level certification.
Mhm.
This isn't like our level of experience, because there's so, I mean, I'm trying to go back in time, like it's been a long time now, a couple decades, like trying to think about what it was like when I was first like a certified law student working for a juvenile practitioner, and what I didn't know then that I know now, and there's so much. And
Yeah.
that doesn't mean I did a terrible job back then. Were there things I could have done better? Absolutely. But we all have to start somewhere. And so I also, like, some of these things that we're talking about, I'm even thinking, oh my goodness, it can be so hard currently for people to get certified because they have to co-counsel X number of termination trials, for example, right? I don't know how valuable that is in and of itself. Like, you could observe too, and you could even talk to the lawyer that is doing the case. I'm trying to think about how to get across what I'm trying to say. I just think that we just need to really focus on the floor so that we're not getting, because we keep getting caught up in training, and I can see so many opportunities for training and so many ideas that we all have on how to do that. But how do we get people to the base level? Because we need to get more practitioners into the system.
So yes, it's a good reminder. We do need to be focusing on what the minimum is at this point. Is that so? I think part of it is keeping in mind that not everyone necessarily needs to be independently certified out the gate, that we can have that, what we currently have as the certification under supervision, we can retain that. And I think it's anticipated that we would have alternative ways of getting people in. If anything, I think what we're looking at with this kind of a model for the certification standards would be, instead of having some nebulous other experience route, we actually define what that experience looks like. So say if somebody, like the way I look at it, trial practice, there's a lot of places where you could get trial practice. You can get trial practice as a prosecutor. Never have a client in your entire practice, but you get trial practice. So that might be something that we're like, okay, you've met this particular component of the standard because you were a prosecutor for 5 years. Cool, that works. But you've never had a client in your life. So before we can certify you to work with dependency clients, we need you to have some experience or training or mentorship on how to do that. So we build your mentorship towards explicitly that particular piece that we're looking at. Does that make sense? Yeah, Dawn.
That,
Yeah.
that goes to, I think my outline mentioned, the concept of a clinical plan, a specific clinical plan. I think that is an excellent idea, that if somebody comes forward and says, I want to do this work, here's what I've got. And there's some understanding of what the clinical plan for me would look like. And it might include, I need to be supervised and participate in hands-on client interviewing, and read these 3 books about client focus motivational interviewing, and path, and have some people say something. I think we should definitely look more individual lawyer situation plan for qualification.
Jennifer, you've had, and I went ahead and threw that in as like the number 3 here. If you don't meet all of this stuff, have a clinical plan, and we can flesh out what that potentially language-wise looks like later, but just this is our rough concept. Jennifer, you've had your hand up for a while. Go ahead.
Thanks. This is my 3rd year doing juvenile dependency. So I do remember what it was like to just come into this and be scared out of your mind going, oh my God, I have to speak in front of the judge every single week. What am I doing? That being said, I did have a bit of a background in it, but it was still, or in being in court, but it was still a little nerve-wracking because dependency is a whole other beast. So I think if we're talking about like the online trainings, breaking those down into specific like components, here's your trial practice stuff. Here's the dealing with clients and interviewing kids kind of stuff. So that way, if there's a piece that you're missing as a qualified lawyer, you can have that portion of it. I think if we're going to do anything online, it should be material that you get to keep so that you can refer back to it at times. I also think it's really important to have something within that training component that's in person. So one of the things we've mentioned is that it's really hard to find TPR trials that are actually going. So if we're going to want that to be a separate qualification or a separate certification, then maybe putting in mock TPRs that each county can put on at certain times. So that way, you know, you can address a few different components. You can sort of go through the practice of doing all of that, and you get the procedures that are in your county, because those vary quite a bit depending on which county you're in. And I think that practical piece to it as you're receiving some kind of training is important, because the way that you would have the time to gather your thoughts and type in a trial memo or a trial brief is much different than you're getting information last minute because DHS didn't send something out in discovery, and you're having to formulate an opinion on that, be coherent, and explain it to the judge all in a 10-minute time frame is a much different thing. And as a new lawyer, that tends to really take you outside of your comfort zone. So I think having some practice in that would be great. And that might have to be in person. And then the mentorship piece of it, I think, is going to be really important. If I wasn't able to job shadow the attorney I replaced for a while and then be in a law firm where I could ask a whole bunch of the really dumb questions and trust that they're going to not judge me or think of me differently, that was incredibly important and incredibly helpful. So when we're looking at setting up this mentorship piece to it, I think it needs to be really taken seriously and not as an afterthought, that the people who are doing it obviously need compensation for their time, that they really need to know what they're doing, and they need to be personable enough, or there's a wide enough variety of them, that each lawyer that's coming in can sort of find someone that they don't feel like a complete idiot asking questions in front of. So that's my 2 cents.
That is how I would hope mentorship works. Yeah. Okay. Okay, so let's see if we can flesh out. Are there things that we would want to add to the or remove from the skill? And I feel like this first the first part up here, again with the grabbing the weird thing. This first part, can everybody see this well? Would it be helpful if I increased the size a little? Yeah, okay. Let's see if I can make that a little bit.
I've got it up on the screen on my office.
Okay. This first part feels like if we're going to do a written test, this is where I would probably want to drive questions towards is statutory stuff, but I might be wrong on that. In any case, are there things in the list of skills or like experiential stuff that we want to add or delete? And if there's other ways that you can, I threw together some of the, like, how do we know that somebody's met this? I threw that together pretty quickly. If you think of other ways that we could identify that somebody, training for working with experts, training on BC, and I'm going to still call it NREs every so often because why?
That's what they are.
Yep.
And Kevin, in each of these are or, right? Or this.
No, these are
or,
and.
Oh, in each of these?
No, in each of, yes, you're right, right, Holly. Inside each of them, it's an or.
Okay.
It's, you've got to have A and B and C, but how you get there is
Right.
mutable.
Okay,
range.
so-
So
So-
I guess, oh,
Are
sorry,
we
go ahead,
going
Dawn.
section by, I just want to make sure I understand. We're at item 2.
Mhm.
Going through A, B, C, D, and your ask of us, our deliverable is there anything in each one of those alphabetical lists that we think we should add or delete as experience that you would need to be qualified to handle just the jurisdictional type cases or the TPR and the jurisdictional?
So that's a great question. I wrote this with an eye explicitly just towards, I don't know if, see, here's where it gets into the question, like, are we thinking of the dependency level as everything except TPR? Or are we thinking of it as jurisdictional? Because frankly, I'm not sure that the people who wrote the qualification standards that we have right now were thinking about that at all, right? Like, I don't know that whoever wrote them knew enough. I wasn't there. I don't know when they were written or how they were written. But I don't know that they were considering, most of the work that happens on a dependency case happens after jurisdiction. And there's a heck of a lot of stuff that you need to know how to do before you even get to TPR. You could prevent a TPR by knowing how better to do the other stuff.
Well, I see jurisdictional as like the equivalent of a misdemeanor. Burden of proof is low, right? And think about the adjudication separate from the disposition.
Mhm.
Burden of proof very low, consequence potentially low. And I'm thinking, if you're thinking about the worst kind of case you could have, which is a TPR, is low. So when I'm working with my baby lawyers, I'm thinking, they're all like, as any new lawyer would be, is when I was doing new things, my first misdemeanor trial. But really, you're like, okay, the risk is low and the burden of proof is low. They only got to get to a preponderance. And if you exclude the really extreme conduct cases, the risk is low. Services to get your child back. Your child may stay with you. Your child may actually still currently be with you. Is the court going to be involved with your family while you make your home, your situation a little safer? Then I think that's the first level of practice. And then the next way to think about it is subsumed in that is review hearings or citizen review boards in some counties. We do almost them all. That's a pretty low stakes game. And you would want to be well trained in strategic moves, like playing the chess game that is, building a record to use later, should you ever need it, right? And then are we also going to subsume into that permanency hearings? Are we going to expect another level of qualification to do the permanency hearing? I vote no, because I think it's still kind of it's still within that, it's getting a little more complicated, but it's still not to the next level. I think guardianship motions are in that too. I think I kind of spelled that out.
By guardianship, do you include
durable?
Durable, okay.
Just durable. I think durable is a low stakes game. In my mind, it's generally a low stakes under current Oregon law, a low stakes game for your client. Because if you're thinking parent or child, because anybody, your kid's still a ward of the court, you can litigate what parenting time looks like at any time. Anybody can file, any party can file and get back in front of the court. You can litigate any aspect of it and it might go away. So I vote that we have one set of qualifications for those kind of cases and then another set for TPRs, with the understanding that there could be a mentorship or a co-chairing situation if someone that's not currently qualified to do the TPRs case gets flipped in that direction.
And Dawn, I would second that, but I would add that I think with the TPR, much like with whatever state I said it was, that I think like it was Washington that had 6 months. I think it should be a year. Like you should have to do the dependency level jurisdiction for a year before I think you would even be qualified for the TPR.
I think that that's true. And I think that there's a recognition even currently by the Public Defense Commission that if a lawyer that's not qualified could pair up and both lawyers could get some type of credit, which is a resource compensation, to work together on the case. And I don't, I think I'm kind of torn between, when I came to this practice, I'd been a lawyer litigating in your face litigation for a long time. And so my first TPR, I had not sat through a whole TPR at any time. And but I was an unusual case, and our focus is on sole practitioners or people just starting out, or. So, yeah.
Jennifer, you've had your hand up for a bit.
So when we're talking about having 2 levels, because it sounds like that's maybe where the group is headed, is 2 levels. I think the first one should go through the contested permanency to change a plan to something like a TPR. And the reason that I say that is because practically when you're in a case, by the time you get to the contested permanency, if you don't have an eye for what's going to happen in the TPR, if you don't know what your client needs to do to avoid that or to provide the evidence for that, you're going to set your client up for failure, no matter who takes over the case after that. So I do think that that has to be a component of that first level. And if we're talking about TPRs being an additional certification, I don't know if there's a amount of time practicing dependency that makes sense to then say, okay, now you can look at being qualified for TPR. I think you have to understand it, but realistically, it's a much different trial than anything that you're doing in dependency. And you can be doing dependency for a year and only have 1 or 2 cases that get into the posture of being prepped for a TPR, or they're looking like they're headed that way. And so I think as you're looking at that certification, it should be more about what you can demonstrate, whether that's past experience, whether that's by going through an in-person training module for it, or whether that's by co-chairing with mentors, if that makes sense.
I would add for that, for qualifications for a TPR, I think if you sat through and watched from beginning to end, even if you weren't co-chairing it, someone's TPR, particularly someone maybe whose case you have been able to follow. These these cases are complicated in terms of being able to watch or read transcripts. We've mentioned that before because we can't go by and we can't just go get a transcript like we can if we're trying to get certified or learn something in a criminal case. But it's public hearing, and if you sit through from beginning to end, one or two TPRs, if you had a year's practice talking through and thinking through and been going to some trainings that are TPR qualified, you can do it without a co-chair.
Okay. What I'm hearing is 1 year of practice at the prior certification. And then 1 to 2 contested contested adjudications. That's very similar to what we currently have for TPR. I mean, what we would potentially be doing is making dependency a little bit more concrete, and then just having the same additional stuff for TPR, which do we need TPR to be more defined if we've already set clearer standards for dependency?
I don't think, I mean, I don't think, I think that you can be qualified or to do a TPR trial. Observing one or two in a year of practice and dependency, I don't know that you need maybe you need a year, maybe you don't. It depends on, okay, if it's for solo practitioners, or just starting. I also have spent a career working in essentially a learning hospital, a university hospital, a public defender's office, a large public defender's office surrounded by lawyers all the time. And that's different. I mean, TPR, this is a very serious moment. And by the time somebody's fighting about a termination of parental rights, it is the most serious thing that happens. And it is arguably more devastating than being going to prison.
Yes.
Particularly if you represent the parent. I mean, at least I can't speak for people all over the state, but in Multnomah County, there's a class of cases that are going to TPR. And so it's usually kids that don't want to be adopted are not experiencing a TPR in Multnomah County. You don't see that. So you see little babies who really aren't able to voice their opinions, or people that are there saying, I know what's going on and I want this adoption in terms of kids. So maybe for the parents maybe for parent representation on TPRs, you have the higher, longer period of time. And if it's a child, you lower the amount of practice time from 1 year to 6 months. Like, quite frankly, we try to get our newer lawyers on, like, oh, your first TPR, if it's a baby, and what if you're representing the child, I'm sitting in the courtroom and it's and a little child, a baby, and the AAG, and you're aligned with the AAG, you've got this. I'll be behind you all the way, but you can do this.
So I don't know that I necessarily agree that there would be an experience difference between parent and child rep on TPR. And because there will be that, if for no other reason, then there will be that occasional situation where child pursues the TPR, even though DHS isn't wanting to.
Yeah,
Right.
I mean, I don't, yeah,
Because
it happens.
you've got to take into account that child's wishes are not necessarily always aligned with anyone. I mean, they could be completely separate from everybody. So I don't know that a separate. Yeah, Melissa, totally agree as well. I mean,
Yeah,
my last TPR was one where everybody had a different opinion on what the outcome should be. So, like, yeah.
so one standard.
Rebecca, you've had your hand up for a while. Go ahead. Uh-oh, did we lose Rebecca?
Okay, hold on. Okay,
There we go.
sorry.
There we go.
I'm in my car, and you said Rebecca, and I'm like, oh shit! Now my screen is all messed up. So first of all, having just completed the Driscoll trial last month, which I think Dawn may still have some PTSD about, I would agree that sometimes weird stuff happens and the child's attorney might have to carry the whole damn case. So you never know. Having said that, I would also have a question. We are talking about different levels of certification, which I don't disagree with. TPRs are incredibly complex, and I agree with Dawn's statement that they're, in my opinion, and I think in the court of appeals, in the court's opinion, is some of the most important shit that happens in the courthouse.
Mm-hmm.
So what we're talking about makes sense. However, I keep thinking about my baby lawyers who I'm mentoring, and what happens if you as a solo practitioner are only dependency qualified, you handle a case, it gets all the way through contested perm hearing, and the plan is changed, and now you're not TPR qualified, but you represent these people. What happens? Does another lawyer have to come on? Like, what's our plan for that?
I proposed a co-chair system that
Yeah.
recognizes.
Like, who's going to do that? Are there going to be lawyers who just jump on and say, I'll come onto this case at the end of it, like Dawn, bless your heart, tried to do? Like, is that what's going to happen?
Well, I think it would be like, maybe, I mean, I don't know what different counties do, but we usually have a fair amount of time. But someone could, I think you could apply to Office of Public Defense Services for that co-chair with the TPRI when you see it headed towards a contested permanency hearing. I think that's when you should get on board, because that's when the strategy really starts. You start playing chess, right? And Driscoll is an outlier for sure, without saying too much. I would agree. Outlier.
I know. I've been practicing. Some of you guys are like 5 years, and I'm like 27 bitches. But anyway, I'm like, I get it, Dawn. I get it. So what I do is I just jump on as co-counsel for my lawyers and let them take a witness here and there if we're going to do that. But that's because I'm part of a firm and they're my employees. So I think that we need to make it clear then in these standards that if we're in a situation like that, that there's a list of lawyers that are willing to jump on and do that.
So I think for the right price, there always is, right? I mean, we have co-chairs. It's a murder case. This is a murder case. We do solo practitioner co-chair murder cases in this state. The qualifications.
I would be on that list. I would be happy to be on that list.
I could certainly see us changing our current co-counsel policy to include TPRs either as discretionary or possibly mandatory co-counsel. I don't know that we would necessarily make it mandatory like we do for murder one, just because the mandatory means what we really want is everybody should have two attorneys if they're facing a murder one charge. And I don't know that every TPR needs 2 attorneys on it, but I could certainly see that as something that we could potentially move in and like if that's what the work group recommends, I can certainly add that to our recommendation on how
Recommended.
other policies change.
Well, and I think so, Kevin, I think like in practical effect, like at least the places that I practice, that has just happened regardless of whether, however it's counted or not. I think that that's just the way, I mean, I'm co-counseling one with someone right now because they've been doing dependency work for 4 years and haven't been able to do a TPR trial because so few go to trial. You know, they're doing a lot of it, but I'm still there with them making, doing my part to ensure that the client's case is being handled in the best way possible. But there's nothing about the attorney that would require co-counsel except for the fact that they don't yet meet the standard.
I agree with that. We've got, I mean, this situation comes up, and one of the things, my reference towards putting in co-counsel policy just makes it really clear. Everybody, like, if you're co-counseling it, you get credit. Like, that's how this works. I also want to note that and I don't know if I've mentioned this in this work group yet. One of the things that we are looking at taking from the Massachusetts model is the regional supervising attorneys who might be able to fill that role as well. I don't know whether that's really, I think they're anticipated to carry a case like a smaller caseload and also do mentorship and supervisory responsibility for the area, but the details of that haven't been worked out yet. So some of this is, we have options on how to fill that gap. The question is what those options are going to look like as we build policy in this whole paradigm shift that we're going through right now. So yeah, I'm right there with you guys. Rebecca, your hand is still up. Was there more?
I don't know how to put that damn thing down. Hold on. I'm sorry.
No, you're good.
There's always more. There's always more, Kevin. What do I just click on it? But okay, just assume my hand's not up, Kevin. Just assume my hand's not up. All right.
I do want to make note, because everybody's time is valuable, that it is essentially 6 o'clock. And I don't know what everyone else's plans are this evening. I could probably stay around for a little bit longer, but I will need to head home soon. What are everybody else's thoughts? I don't know if we're quite at the right stopping place yet, but maybe others feel differently.
I think that we're at the right stopping point if you give us a task for the next meeting. Like if we solidify a task for us to be thinking about, so when we get together next time we can build on this, because I think we made some good progress.
I agree. Okay.
Just, if I may, before we
Jennifer.
switch just a second, if we're talking about co-counsel, which I think is a really great idea, especially for someone who hasn't met the qualifications, we really need to think of the practical effect of that before we put it in the certification. So is this everyone who doesn't meet that yet, but is able to practice dependency? Are they going to get assigned an attorney to reach out to for if they get to that point of a TPR? Is there going to be one just for the region that then gets appointed at the conclusion of a contested permanency where the plan gets changed? Like, how is that going to function? Is it something we have to give notice of in the court? And is that pool of co-counsel going to be readily available for people, especially who are solo practitioners? Because they're going to need to know the names, know when to bring them in. Is that the court's going to appoint them? So then that works for the mentor's contract or the co-counsel's contract kind of a thing. So really think about that before we put it in the certification process. Because if it goes the other way, it causes a cluster.
I would like to say, once the court determines that someone is qualified for court-appointed counsel, it's none of their business how many lawyers. Like if that was a private person, if that was a rich person, they could bring in 6 lawyers. Okay, so I don't think we have to reach out to the court and ask court permission to have co-chair if we think, to meet the constitutional and statutory requirements for competent counsel, that 2 lawyers are needed. So I don't, I'm really strong on that because, you know, the, the, the courts have a different interest. They want everybody to have a lawyer, but they also want to move cases. They don't want nothing to slow it down, right? And and so we don't need to consult with them about whether we want two attorneys on the case.
And-
So I'll say the way it currently works is either the attorneys file a motion with the court to have a second attorney appointed, which courts routinely grant and never tell us. But the other way is that we do have people reach out to us for co-counsel requests as well. And I mean, we have some loose guidelines on I mean, if it's a murder one, it's mandatory. We automatically approve it. If it's anything else, we have a loose idea of guidelines as to what cases should be getting a co-counsel or not. The one thing that we do currently have a not unbreakable, but it is a fairly significant rule is that we don't grant paid co-counsel for the explicit purpose of getting somebody qualified for higher levels of certification. This may be a sphere in which we want to change that rule, given how very likely it is that someone could not meet the TPR certification standard within the time period of their first dependency case. So that's a thing that we would want to work on later. But Holly, go ahead.
The last thing on this topic, and then I agree, like we can, I think what Dawn said, have a task so we're ready for next time, but is that, again, just really, and I know, Kevin, you were in Douglas County, like you understand this. In our smaller communities, there's not a lot of us doing this work, and we have high issues with conflicts. Like those of us who've been practicing for a little while, and even if you haven't, you know, that it's difficult to, I mean, oftentimes every lawyer that can is on a case, is on one of these cases. So asking someone else to be co-counsel as a requirement on a TPR would not be someone in our community. And I mean, in all likelihood. So to your point, Kevin, like you were talking about the regionalization of having maybe, you know, someone that we would be able to utilize for that, that would make the most sense because it's going to be a struggle to find someone who doesn't already have a conflict and could jump in that was already qualified. So just an issue, I think, more in the rural parts of the state, again, being mindful of that.
Okay, I agree. Conflicts are a huge issue in a lot of, okay, then let's go ahead and break for the evening. And here is the task. I'd like to firm up and get recommendations on item number 2 for the dependency qualification list. Let's see if we can't firm that up. Whether that is, if you have specific recommendations for what numbers should be in here, great. If you have specific recommendations for what other skills or what other practical experience, perfect. If you think something, I'm not sure about project management. I threw that in there because we were talking about it last time. Maybe it's a good fit, maybe it's not. What does it even mean? Let's firm some of these things up. And that, I think, is our primary goal for next session. I don't know whether it'll be next week, although this time does seem to be what everybody keeps picking. So I'm going to send out the doodle poll. It'll just be next week time slots. We're not meeting tomorrow, and I'm not going to come in on the day after Thanksgiving. So, okay. Does anybody have any questions before we break?
No, thank you so much, everybody, for listening to me tonight.
Thank you, everybody. Your help here is immensely appreciated. So have a great night. I will see you all probably sometime next week.
Happy Thanksgiving, everybody.
Happy
Bye-bye.
Thanksgiving, everyone.